Hey guys, Marcus Melnick here with Firearm Mentor. Hope you're enjoying my YouTube channel. Don't forget to like, share, and subscribe. These little things are free to you and really help the channel. I appreciate your support. Enjoy. Thank you.
The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters. Greetings and welcome to the Personal Safety Show. This is Marcus Melnick from Firearm Mentor and Stress to Logic, your host. And we have an action-packed or explanation-packed show for you today, which is going to discuss the recent ruling on the PICA Act, Protect Illinois Communities Act, or if everyone has always heard me call it the PU Act because I think it stinks. So before we get into it, I kind of want to update everyone on a website development that I made to my firearmmentor.com website. If you go to firearmmentor.com/swag, SWAG, the Firearm Mentor now has items for sale. That includes a light blue woman's t-shirt that says, "Women shoot better than men. Just ask my mentor." And then we also have men's t-shirts with a really interesting picture on the back. You have to click into the photo to actually see the back, which has an 8-inch revolver and a 6-inch semi-automatic, and it has a question on it: 6 inches or 8 inches? Also available is a 3D printed revolver cylinder that can be used for things like makeup brushes, Allen wrenches, but it's really a pencil holder. If you get any of this themed logoed stuff, be careful about putting it on your desk at work because we don't want to offend people. I also have a 2-in-1 cleaning brush with one side being nylon bristles, one side being brass bristles, and of course the 3 books that I authored. The first one is called Handguns: The Adventure into Shooting Sports. The second one is called The Opposite of Safe: Understanding the Mental and Physical Reactions to Mass Shootings, Criminal Violence, and Other Horrific Events. And then finally, my most recent book, which came out earlier this year, Overcoming the Hot Stress Mess, which is a companion book to my TED Talk and my corporate training on how to beat, overcome, and bypass the human stress response. So let me explain something also, segueing to my listeners. I'm going to segue and explain. Last weekend, there were a lot of reports that came out regarding Judge McGlynn's decision on the PICA Act, and I specifically did not discuss it in my episode last week because rather than reading what all of the media outlets have said and their summary, I wanted to read the 169-page decision myself and draw out conclusions from it. And I will be going over that decision, not in super fine, boring detail, but I'm going to give everyone the highlights of it. And to summarize it, Judge McGlynn ruled PICA unconstitutional. However, he has a stay on his decision for 30 days. Which means the state now has an opportunity to appeal to the appellate court. So if no appeal is entered, the judgment will stand. PICA will be revoked. However, chances are, and I already know that the state's already drafted their rebuttal. I'm not sure if they submitted it yet. So the legal battle does continue. So for all intents and purposes, the PICA Act is still in force. We cannot purchase any of the banned items, any of the what I call standard capacity magazines yet. We were hoping for a Freedom Week, kind of like we had last April. However, that did not happen. So stay tuned for updates on that, and I'm going to go through the decision right after this break. I want my listeners to know that this is my dream, teaching people about safety. If it weren't for you, if it weren't for my listeners, I couldn't live my dream. So on behalf of my family and myself, I want to thank each and every one of you for allowing me to live my dream. And I also want to continue to live my dream, and I'm excited to continue to spread the word of safety. Recently, I began a new service as a conference keynote speaker. So, if anyone would like for me to speak at future events, or if anyone knows of an introduction or would like to discuss how we can work with one another, I'd love to do just that. The keynote speaking website is www.stress2logic.com. That is STRESS2logic.com. If you're aware of any conference speaking engagements where you'd like to have me speak, I'd love an introduction. You can always share my electronic business card, which is Marcus Melnick, MarcusMelnick.com. Now, back to the show. Historically, there were 4 cases that were combined. The lead case is Caleb Barnett versus Kwame Raoul. That case number, if you wanted to look it up, is 23-C as in Charlie, V as in Victor, -00209, -S as in Sam, P as in Paul, M as in Mary. The other cases that were enjoined with this one is Dane Harrell versus Kwame Raoul. That case number is 23-C Charlie, V Victor, -00141, -S Sam, P Paul, M Mary. And then there's Jeremy Langley versus Brendan Kelly, case number 23-C Charlie, V Victor, 00192, -S Sam, P Paul, M Mary. And finally, the FFL of Illinois, or Federal Firearms Licensees of Illinois, versus J.B. Pritzker. And that case is case number 23-C Charlie, V Victor, -00215, -S as in Sam, P as in Paul, M as in Mary. And what I'm going through is the findings of fact and conclusions of law written by Judge McGlynn. And I'm not going to read you 168 pages worth of an opinion, but I'm going to draw out some of the highlights. So Judge McGlynn has written, "In life we face many perils. Some are natural weather phenomena, such as hurricanes, tornadoes, or floods. Some are biological, such as viruses, disease, or malignant cells. Some are perils associated with important products like electricity, natural gas, matches, automobiles, and even pain-relieving medications. Too often, the perils we face are forced upon us by other people, by people who are negligent, reckless, insane, impaired, or evil. Sometimes it's a proverbial lone wolf, sometimes it's a whole wolf pack. Truly, life comes at you quickly. And who comes to the aid? Who comes to our aid at the times of peril? Sometimes it's the police or first responders. Other times it's healthcare professionals. Sometimes it's family, neighbors, or friends. And sometimes it's no one." In his opinion, the judge also said that the AR-15 is the Rorschach test of America's gun debate. In listening to the political debate and reading various judicial interpretations of what the AR-15 represents, it's obvious that many are seeing different creatures. Some see one and not the other. And the task of the court is to determine the reason for the varying interpretations. Sometimes you see a dragon to be slayed or a horse to pull a carriage, but sometimes the perspectives are defined by whom they picture using the weapon, either a menacing criminal or a law-abiding citizen involved in a dangerous situation. PICA criminalizes knowing possession of hundreds of previously lawful rifles, handguns, and shotguns. It also bans various attachments, accessories, configurations, and so-called, quote, large capacity, end quote, magazines. It also created a firearm registration program requiring registry of arms possessed prior to January 1st, 2024, earlier this year, the date after which PICA would be enforced. The stated impetus for imposing these sweeping gun restrictions was a tragic incident where a young person armed with a semi-automatic rifle opened fire on a crowd gathering for an Independence Day parade. The goal was to impede violent criminals by deploying semi-automatic firearms and ammunition magazines designed as, quote, high capacity. I'm segueing away from the decision just to make a little comment. I heard Eric Reinhart, the state's attorney for Lake County, speak about this topic. And very passionate guy, very transparent, easy to talk to, talks to his constituents, which was refreshing to me. And he made the comment of there's already a ban on AR-15s in Highland Park, and it didn't help prevent the shooting. Yet, he still is in favor of an assault weapons ban. I have no idea if it's the long game where they're going to say, well, we're going to ban these throughout the country, therefore in 50 years, then maybe shootings will stop. That's not a real good situation. Anyway, back to the court decision. Judge McGlynn goes on to say there's no happy consensus on guns, particularly those defined as, quote, assault weapons, end quote. With malice towards none on either side of the debates and with no desire to impose policy judgments by judicial fiat, this court seeks to understand what exactly it means for a firearm to be dangerous, unusual, bearable, in common use, in dual use, and or a military weapon. As the Second Amendment's guarantee centers around the right to self-defense, one cannot identify the delimits of its reach unless one understands what falls within the parameters of confrontation with an adversary. The court will examine the soldier and military confrontation as well as the civilian and dangerous or deadly confrontation and determine whether clear lines of demarcation exist between the two and where those lines may blur. Some of the cases that Judge McGlynn referenced in his decision have come before us, and the first one is District of Columbia versus Heller, and that was in 2008. McDonald versus City of Chicago, that was 2010. New York State Rifle and Pistol Association versus Bruin, 2022. United States versus Rahimi, earlier this year in 2024. He also examined dissenting opinions. It's also worth examining the dissents in Heller and Bruin to see which interpretations and analyses of the Second Amendment were rejected by the majority in those cases. So the dissenting justices in Heller advanced two independent arguments against the majority decision. Justice Stevens argued that the scope of the Second Amendment did not extend further than militia-related interests. Additionally, Justice Breyer argued that even if there is a self-defense interest in the Second Amendment, that protection is not absolute. Rather, a violation of this protection must be due to the law being unreasonable or inappropriate in Second Amendment terms, and that was in D.C. versus Heller. And Justice Stevens not only opposed the majority holding regarding the District of Columbia law at heart of the case, but also found that the scope of the Second Amendment described by the majority to be entirely absent from both text and drafting history of the document. Unlike the majority opinion, Justice Stevens found a plain reasoning of the text to do no more than provide a, quote, right to keep and bear arms for certain military purposes, but that it does not curtail the legislature's power to regulate the non-military use and ownership of weapons. This narrow reading of the Second Amendment begins with the text of the preamble, in which Justice Stevens found three important points. First, he found that the purpose of the amendment was to preserve the militia. Further, it established the militia's importance to the preservation of a free state. He also found that the preamble recognized that this militia must be well regulated. The focus on the role of the militia in the newly formed nation defined Stevens' view of the scope of the amendment, which he saw further bolstered when comparing the Second Amendment to similar provisions in state constitutions. For example, provisions of the Pennsylvania and Vermont constitutions discuss not only the right to bear arms for the preservation of the state, but also for purposes such as self-defense and hunting. There's more to the story. You guys can read the case, go online, look up the PICA decision with Judge McGlynn. I don't want to bore you with some of the details, but again, just like society, judges are not all in agreement. They all interpret the law differently. Justice Breyer's dissent in New York State Rifle and Pistol Association versus Bruin contains a different vision of Second Amendment protections than the majority. Unlike the majority, the dissent would have engaged in means-N scrutiny, and that takes into account not only the historical tradition of firearms regulation exclusively, but also allows the court to take account of the serious problems posed by gun violence. As recounted by the dissent, these problems are not only serious, but are becoming more prevalent in recent years, with gun violence increasing by about 25% between 2015 and 2020. And this, he quoted the CDC on that one, so that's a decent source. And Breyer was also deeply concerned upon whom this issue falls, with gun violence becoming the leading cause of death for children and adolescents, as well as disproportionately affecting African American communities. And this is from an article in Time magazine. And the Centers for Disease Control and Prevention, age-adjusted rates of firearm-related homicide by race, Hispanic origin, and sex, National Vital Statistics System in the United States. In addition to the tragedy of this problem, the dissent also recounts how it is unique that when compared to other similar nations, our nation ranks the highest in gun violence. The dissent further discussed how the problem of gun violence makes other scenarios more dangerous and deadly, including road rage incidents, protests, domestic disputes, and police interactions. And he goes on to quote Everytown for Gun Safety, Armed Assembly. So this is a guy who really doesn't like guns, unlike my listeners, unlike myself. In summary, the Supreme Court majorities in Heller and Bruin explicitly rejected the following notions. First, they rejected the argument that the scope of the Second Amendment did not go further than to protect a citizen's right to keep and bear arms for military or militia purposes. They also rejected the argument that the people, quote, people identified in the Second Amendment referred only to the collective actions of individuals under a duty to serve the militia. The court flatly rejected any notion that the term bear arms related only to military service or acting as a soldier. Additionally rejected was the notion that the only concern addressed by the Second Amendment was a fear of standing armies. Also rejected was any notion that the self-defense interest advanced by the Second Amendment was nothing more than a, quote, subsidiary interest. The majority decision in Bruin explicitly rejected the call to apply any form of means-to-end scrutiny to Second Amendment challenges, thereby rejecting any notion that the Second Amendment must yield to a state's, quote, compelling interest, end quote, even when such an interest can be demonstrated by compelling data. Justice Breyer's argument that the complexity of firearm regulation reserves this issue, quote, only for legislators' discretion, without the possibility of judicial review, was also rejected. The fact that urban and rural communities suffer from gun violence in different ways, or that different firearms pose different risks and different purposes, was rejected by a justification for broadly insulating the legislature from extensive judicial review. The Bruin Court also rejected the argument that history alone would be both impractical for judges to utilize and incapable of providing definitive answers. Aside from means-ends scrutiny, the majority in Heller rejected an interest-balancing test that would have weighed the burden of the Second Amendment against the government's interest in enacting the law. Finally, Bruin's dissent's understanding of history was rejected as a justification for the public carry legislation at issue in the case. English and colonial, quote, going armed laws, end quote, the Statute of Northampton or colonial laws prohibiting the carry of unlawful weapons were rejected as a justification for New York's licensing regime. Similarly, founding era laws that mirrored the Statute of Northampton were rejected as proper historical analogs to the New York law. Even concealed carry laws and surety laws from the 19th century failed to justify the law struck down in Bruin. Finally, regulation that went as far as to prohibit the carrying of firearms in public also could not stand as justification for New York's public carry law. The Supreme Court, in rejecting the dissent's arguments, made clear that these regulations did not demonstrate a historical tradition of regulating firearms that would justify all modern legislation. This court case also took a look at definitions. Justice Thomas wrote that the Supreme Court's minimal guidance is far from a comprehensive framework for evaluating restrictions on types of weapons, and it leaves open essential questions such as what makes a weapon bearable, dangerous, or unusual. In Heller, the Supreme Court wrote, at the time of the founding, as now, to bear meant to carry. So that is one definition. When used with arms, however, the term has a meaning that refers to carrying for a particular purpose, confrontation. The Supreme Court notes Justice Ginsburg's definition from her dissent in Muscarello v. United States. Surely a most familiar meaning is the Constitution's Second Amendment indicates wear, bear, carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive and defensive action in case of a conflict with another person. In the Beavis case, the Seventh Circuit asks, what exactly falls within the scope of bearable arms? Not machine guns, the Heller court said, because they can be dedicated exclusively to military use. Yet a normal person can certainly pick up and carry a machine gun, or for that matter, a portable nuclear weapon, mentioned at the outset. Bearable thus must mean more than transportable or capable of being held. In additional context, the Third Circuit attempted to refine which bearable weapons and arms are in the context of the Second Amendment. In a concurring opinion, Judge Roth of the Third Circuit wrote, although weapons can be and are used for lawful purposes besides self-defense, including recreational target shooting, hunting, pest control, that Heller holds and its progeny affirms that the self-defense is the core lawful purpose protected by the Second Amendment. And that while these other uses may be lawful, the Supreme Court has never recognized them as core purposes protected by the Second Amendment. Until it might do so, the bearable arms presumptively protected by the Second Amendment are limited to weapons used explicitly for self-defense. Some of the circuits, including the Seventh, demanded that the right to keep and bear arms for any lawful purpose to be narrowed to bearing arms only for self-defense in the home unless the weapon is an arm useful for military purposes. This asymmetry can easily derail any effort to fashion a neutral definition of what it means to bear an arm. It's not necessary to narrow the definition of what constitutes bearable to address only what is bearable for the purposes of self-defense. The concerns of the circuits with respect to semi-automatic weapons, attachments, configurations, and mag capacity are more aptly addressed in how one defines dangerous, unusual, or military. It's critical that one doesn't gloss over the language in Heller that says the Second Amendment extends prima facie, which means on itself it is proven, to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Prima facie means legally sufficient to establish a fact or case unless disproved. So that was a bunch of legal mumbo-jumbo. Let me give you the real down and dirty definition of prima facie. A yield sign is prima facie. So if you're driving and you have a yield sign and you don't stop and you get in an accident, it is your fault because you did not yield. The court's upheld. Yield means yield. That's what prima facie means. It means if it's established, it's reasonable, it's going to be illegal. That's basically what that means. So any handgun, shotgun, or rifle that can be picked up and carried, is that a bearable arm? Is the ability to safely operate the weapon a function of whether it's bearable? Some guns might be awkward, cumbersome, or ponderous to hold, aim, and fire, and they may be inherently unbearable to some and not others. I wouldn't have a 100-pound, very thin person shoot a Desert Eagle at the first time they shot, because it might be unbearable for them, yet a .22 might be actually bearable for them. So how do we treat a weapon that's only partially borne while operating it? Well, consider an arm that can be deployed remotely or by operation of radio control. The court acknowledges that this might be deemed many to be relevant and what is bearable. However, given the types of arms banned by PICA, these queries are more properly addressed in the definitions of the other terms infra. Therefore, the court defines bearable as a weapon that an individual carries for the purpose of being armed and ready for offensive or defensive action in case of conflict with another person. When we return in part 2, we will continue to go over Judge McGlynn's decision in the PICA Act. So, stay tuned. Folks, before we go to break, if you're in need of a CCL renewal or you're interested in an initial CCL concealed carry license certification, our last class of the year will be the weekend of December 7th and 8th in the northwest suburbs. You can sign up at firearmmentor.com/classes. Hope to see you there. The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters.